Let's first start talking about ERISA versus non-ERISA disability policies or plans. Now, the benefits provided to you by your employer, even if you paid some or all of the premium, are probably governed by a law called the Employee Retirement Income Security Act. There's an exclusion, though. It doesn't apply to government or church employees. And there are some similarities, however, when we see these policies, regardless of whether or not it's an employer-provided plan that's governed by ERISA, or it's a plan or policy provided by government to government employees or church employees. So what are the features of an ERISA policy that are unique to the world of ERISA? Well, first, there's no individual underwriting, so nobody's checking on your medical background. And as a result, the premiums are low. There are limits on how long you can be paid for conditions such as mental nervous conditions or subjective medical conditions. There are also reductions for benefits. Those are called offsets. So you'll see offsets for Social Security disability benefits, workers' compensation benefits, personal injury benefits, pension benefits, or other benefits. Now, if your claim is denied, you have to follow the ERISA appeal process and exhaust any legal remedies before you can file suit in federal court. You just can't say, I'm going into court and I'm going to sue these guys. The impact of that is if you try to do that and you don't file an appeal or a timely appeal, your case is going to be over. Why? Because the disability carrier will argue that you have not exhausted your administrative remedies, and most judges will agree with them if you haven't filed an appeal. The failure to exhaust your remedies is an automatic death blow to your case. Well, what are some of the other differences? Well, in an ERISA case, a federal judge is going to make the decision. There's no jury trial. The standard that the federal judge has to use is found in your policy, and it can be several standards of review. The first one is a de novo standard of review. That means the judge can use his or her own discretion in the case and substitute their own judgment for that of the disability carrier. The more common one and more deadly one for an ERISA policyholder or plan participant is the arbitrary and capricious standard of review. That means that the judge is constrained by the opinion of the insurance carrier and can only overturn that denial if they find that the denial was arbitrary or capricious. And that means that insurance companies are given a great deal of leeway in interpreting the terms of your policy and deciding whether you're disabled. There's no treating physician rule, so carriers can use their liar for hire doctors to deny your claim. And if a federal judge, reverses the denial, you only get paid what's owed. And there aren't any damages like punitive damages or bad faith damages. And you might get your fees paid by the disability carrier. What's the difference between that and an individual disability insurance policy known as an IDI policy? Well, a disability policy is one that you purchase on your own through an agent, and it's governed by state law. Usually, individual disability insurance policies will have the following features. First, you're underwriting the policy based on yourself, and you have to have evidence of insurability. You are going to be paying relatively high premiums because this policy is customized to you. There may be limitations on coverage for mental nervous conditions, and you can bargain for the removal of those. There can be offset provisions that generally you won't be able to argue about those, but more often than not, I don't see offset provisions in individual disability policy. The obvious drawback is that this is a customized policy unique to you, and as a result, you're going to pay a high premium. Now, if for some reason your claim is denied, you can file a lawsuit in federal court, and that's great because you can ask for bad faith punitive damages or other state law claims if your claim's denied. And you get a jury trial with discovery, and there's the potential for significant money damages if the jury finds that there are benefits due for bad faith damages. So those are just some of the differences between ERISA disability policies and individual disability policies. And as a subset of that, I'm often asked, well, what's the difference between short-term and long-term disability benefits? Well, short-term disability benefits will provide benefits to a person for a short period of time. Now, the duration is normally 6 months, but it can vary from policy to policy. Those benefits are generally paid weekly, and they'll pay a varying percentage of your salary, and you get to generally pick that percentage. Now, some states will offer short-term disability benefits on their own, like New York, for example, or California. That's not to be confused with short-term disability benefits. Long-term disability benefits is an option that you can purchase. That will provide benefits normally to age 65 or retirement age. It will pay 50 to 70% of your base salary on a monthly basis. But of course, there's always an argument about what that base salary definition means. It's not uncommon for long-term disability policies to provide residual benefits if you're still working, which means if you're earning 80% less generally than what your base earnings are, you get a percentage of the difference. That's the ceiling. The basement is if you are earning under 20%, those before monthly income benefits, you get 100%. So it's that basement ceiling range of 20 to 80% where potentially you might have residual disability benefits. Long-term disability benefits can be taxable or non-taxable depending on how the premium was paid. And so those are some of the differences, if you will, between short and long-term disability benefits.